So a bunch of drug companies have responded negatively to the ruling by Judge Matthew Kacsmarek banning the distribution of the FDA-approved abortion drug mifepristone. What's going on here? Let's talk about it in today's video. Hi, I'm Mike Greiner. I'm a lifelong Democratic activist who's concerned about the direction our country is taking. I'm also a lawyer and an academic, and I'm here to help you stand up to the BS of the MAGA crowd. So Judge Kacsmarek's opinion is deeply flawed in many ways. It turns out, of course, that Judge Kacsmarek lied about his position on the abortion issue when he was going through his confirmation hearings in Congress, even going to the extent of having his name removed from a law review article he'd already submitted that attacked the Obama administration for its position on abortion and on gay marriage. It's all part of the desperate Republican efforts to hide who they truly are from the people voting for them. But at least a lot of the time when you read these opinions, they seem to have some basis in law. Not so with Judge Kacsmarek's opinion. I mean, setting aside some of the explosive language that he used in his opinion, something that judges will try to stay away from, typically, and the fact that this abortion pill had been in routine use for more than 20 years, this case should have been thrown out as a matter of course from the very beginning. The reason is the idea of standing. The people who brought this case are a group of doctors who claim that having to take time to treat patients who had side effects as a result of the abortion pills took time away from the rest of their practice. That's the harm that they claim they've suffered that entitles them to bring this lawsuit. Now, you have to understand, the way courts work is you need to have standing. Courts don't like to engage in theoretical discussions. There has to be an actual case in controversy that they're deciding. In other words, you have to have two parties who are directly involved in the case, each of whom have something at stake who are litigating it. Now, an example of that is we saw a case brought by some women against some of these abortion restrictions because they were denied needed healthcare procedures because of the fear that the healthcare providers had that they would be prosecuted under these onerous abortion restrictions. That is an actual harm that they have suffered as a result of this law, and it entitles them to bring a claim. These doctors, they were just doing their job. They were still paid for their work. I mean, in theory, if they could find someone who actually didn't get treatment as a result of the fact that one of these physicians was treating somebody as a result of the complications from the abortion pill, then that person might actually have standing to bring a claim. But the reason they don't have anybody like that is because there is nobody like that. Nobody was denied treatment because someone had side effects from the abortion pill. So that case should have been thrown out right from the get-go because the plaintiffs lacked standing. And the fact that the Fifth Circuit didn't immediately throw out this case just shows how political they are as well. Just as an aside, the panel from the Fifth Circuit that reviewed Kacsmarek's decision and partially stayed the order was made up of two judges appointed by Trump and one by George W. Bush. So it's not like this was some group of radicals, and even they thought Kacsmarek had gone too far. Nevertheless, they still allowed the case to go forward despite this fatal flaw on the standing issue. But why are the drug makers in particular so upset about this? Well, it has to do with two legal concepts that are very near and dear to their hearts. The first one has to do with administrative law and the concept of abuse of discretion. And the second one has to do with the idea of finality of judgments. So let me talk about each one in turn. Administrative law is the area of law that deals with the various administrative agencies that are in charge of implementing federal law. You see, when Congress passes laws, no matter how complicated these laws are, the United States is such a huge and diverse country that inevitably there are going to be issues that come up with how does this get implemented. Those issues have to be addressed by the administrative agencies. And what federal law has done is given them a procedure that they follow to determine how they're going to implement these laws that sometimes leave quite a bit of room for discretion. Well, the first thing they have to do is they have to promulgate rules. And that process involves public notice and then giving the public an opportunity to respond to a proposed rule. And then the experts in the agency who have to have a background in the area. So, for example, the FDA, you'd be talking about physicians. And what they would do is review the evidence as well as the comments from the public before deciding that a rule should be finalized. Now, generally speaking, the way courts have handled these rules is that they've given deference to the experts in the agencies, understanding that these experts understand the nuances of the issue and the complexities of the issue much better than federal judges. I mean, I'm guessing Matthew Kacsmarek does not have a degree in medicine. In fact, I know he doesn't. He's a lawyer. And no matter how good a lawyer he is, he certainly cannot have the full understanding of the way medicines operate on the human body, the way someone who's trained in that field would. So in general, courts have taken the position that they should defer to the experts in the agencies when it comes to these matters, unless the experts have engaged in an abuse of their discretion. Well, what does abuse of discretion mean? It means that, for example, they did not follow the process the way they're supposed to, or they did not consider all the available evidence, or they made a decision that clearly does not comport with the evidence. Well, what Kacsmarek has done here is he has essentially stepped in and said, as a federal judge with no background in medicine, I know better than these experts at the FDA as to whether this pill should be approved or not. And I know better than the doctors who've been prescribing this pill for more than 20 years whether this pill is safe or not. And that is the first issue that these pharmaceutical companies are responding to. They're used to dealing with the FDA. They know the process they have to go through there. What they're concerned about is if after they go through the gauntlet at the FDA and get a drug approved, that suddenly they'll be fighting in the courts, maybe even years down the road. This is simply an issue that courts should stay out of once the FDA has made its final decision, as long as, again, the FDA did not abuse its discretion. The second concept that the pharmaceutical companies are responding to is the idea of finality of judgment. And what that is after a certain amount of time, you need to have a law you can rely upon. Laws might be bad laws, but at a certain point, people need to know what the law is. And if the law is constantly subject to reinterpretation and changing, then they're never going to be able to have some kind of confidence that their behavior either complies with the law or violates it. That's why in American law we have this idea of finality of judgment, which is that once a decision has been made, we're going to let it lay. That it takes an enormous amount to try to overturn an earlier decision because people are going to be relying upon that decision. They're going to expect that that is the law. And if there's the sense that laws can easily be changed by courts years after they were implemented for very little cause, then that suddenly raises the specter that people aren't going to be able to rely upon court decisions anymore at all. So these are two important legal concepts then that the pharmaceutical companies are saying, wait a minute, if this decision by Judge Kacsmarek is allowed to stand, whether we agree with the specifics regarding the abortion pill or not, our concern is what's going to stop it from affecting other medicines? What's going to stop some anti-vaxxer from claiming that some vaccination isn't safe after it's been administered to millions and millions of people? We need to know what the law is so we can abide by it. And what Judge Kacsmarek's decision does is it completely undermines that concept. Well, if you want to see another video where I explain the complexities about the abortion issue from a legal standpoint, check out this video over here. I'll see you then. In the meantime, let's hope for continued progress. Thank you.